don't do a plan. It's just what they have it for you. It's dictated under the code. So let's say, and I'm referring to a guardian, and again, a lot of you are younger. It could be a period of incapacity. It doesn't mean that tomorrow we're going to not here. But what happens first that people don't realize is that there's actually a period of time you're just unavailable. I mean, it could be due to an accident, it could be due to a normal aging process, but you're just unavailable for a period of time, and there hasn't been something legally documented in writing that you want to care for your kids. But again, in the default, parents and siblings, those persons have the priority. So absent a writing from you, if your cousin knew, hey, Christina mentioned she would want me to do that. So let's say something happened to you, you didn't have anything in writing, but she does, she's prepared, then we would have an issue because there might be someone else with that priority, putting themselves out there first in line. And what does a judge know? They're just going to kind of go with what the code says, and they make the decision ultimately versus us kind of controlling it. Anyone else want to volunteer a thought, even if you haven't put it in writing? Have you thought about it at all? Does anyone have someone who's not local? Julie?
Probably, and my husband and I haven't exact.
Right. Not lining up. It's like yeah.
But probably my brother who lives in Oregon.
Which is no problem. I mean, there's nothing wrong with it. Again, what I encourage people to think about if they're naming someone who has a distance to travel is you need a temporary guardian or first responder. And that person can be sort of who you may, it may even be a neighbor, or it may be the nanny, it may be someone that just has permission to stay overnight with your child, so that it's not, again, a default of child protective services. That'd be everyone's worst nightmare. And I always survey my clients who are involved in law enforcement who get these calls, and I say, what do you really do? And obviously they don't want to involve child protective services. They're going to try their best not to. But ultimately, sometimes when it's a babysitter, one-time babysitter that really doesn't know what the heck is going on and doesn't have the emergency contacts to call with family members, we don't have a choice. And then on top of it, a few times when one client was sharing with me, that person also had to make some medical decisions for the child in that interim, and no one was going to talk to them under the HIPAA and privacy laws. So in addition to, again, not to overwhelm it, some things to think about, having that nomination of a permanent guardian, but also talking about maybe a first responder or the temporary guardians. And then on top of it, giving them permission, again, not only to stay overnight with your child and have temporary custodianship, but also having a medical directive for that minor child that says this person can make medical decisions in my absence, and then having a concise list of who they should be contacting as far as doctors, dentists, and medical information. Again, things to think about. Nothing to do with death and dying, but has to do with, again, possible incapacity, which, again, probably comes up first, and now as people live longer and longer, could be a long period of time. So I haven't even got to, again, a more permanent situation. We're talking about caring for the child, custodianship. Any other, though, volunteers are sharing who they thought about?
My brother lives in England.
Great point. So this person is not a U.S. citizen, maybe even?
Yeah.
Okay. And that's okay. Believe it or not, that's totally fine. He can be approved under your nomination. But guess what? He cannot be in charge of the money stuff. Not alone, at least. What happens is the government, the U.S. government, thinks that that person, because they're not a U.S. citizen, is more likely to take that money and not pay taxes on it because they don't have ties to the U.S. So they say, well, wait a second, you need to be you have to jump through more hoops. So it's okay to have a non-U.S. citizen as a guardian. It's actually not okay to have a sole executor as handling the money stuff. Just an FYI. So interesting rule, but that's okay. Again, in your case, thinking about maybe who's the temporary guardian or first responder. Anyone thinking about naming a couple? 2 people, right? Like, Michael, who are you thinking? So friends, close friends who you thought of naming them together as a couple. Great, because a lot of times some parents feel like it would be very important for a child to be raised in a couple environment. Imagine if you really only named one and the other could sign permission slips technically and things like that. But one thing to think about as you finalize your decision as well too is what happens if they're not together? What happens in the event they're separated at the time this actually comes up, or one of them is unavailable? Are you okay with the other? Who would be your preference? Or does it have to again bump down to that next couple of one? So kind of again, that's what lawyers do. We think about the what ifs. So if a client of mine is naming a couple that I say, okay, we need to think about though in the document identifying what would happen if they're not together or when one of them is available. And it's usually the wife or one spouse looks and says, I'm not okay with the guy alone. But I'm okay with maybe the spouse, the wife. And that's fine, or again, you could indicate up and down. I met with a couple earlier this morning who had concerns about what was holding them up from doing this is they really wanted it to name parents. And grandparents are they're there with the kids are again comfortable with someone. It wouldn't be a huge change maybe for them as much as it would be for someone else. But age is an issue, and that's a concern. And we decided, husband's parents were in their 70s, and actually mom was in 70s, dad was in the early 80s. We eliminated that as a possibility because we just knew it wouldn't be practical. But her parents are actually very young. The mom is still in her mid to late 50s. That was okay. For them, that was comfortable because this document could be updated over time. It's a simple one-page list, and you just update it as time goes on. So you only can't predict the future. Part of what holds people back from making decisions like this is I'm supposed to be thinking about, well, I won't know when this will come up, what the exact situation would be, and we don't. You have to think of it as an ongoing conversation that you would have amongst yourself every once in a while, and then also with your attorney if they've helped draft the documents. Let's talk a little bit about the more permanent situation. So if we had temporary guardians, first responders, those addressed hopefully a night, a 2-night, a week kind of issue. In a more permanent situation where something's happened to both spouses, again, we've nominated guardians, which would be a good first step. Haven't indicated necessarily what about all the stuff? What are the things that I know? And I want to address that a little bit and kind of open up part of that to discussion as well too, because I think there's a lot of common misconception, and attorneys are the worst because we like to use many different words for the same thing. So you'll read on the internet and you'll say, well, what does this mean? Is it the same thing? It's just 3 words instead of 1. It's usually a lot of it's the same. So I'll try to hopefully clarify some of those tonight and get you thinking about what, based on your decision, is most appropriate for you. Let me back up though for a second. Going back to nothing to do with death and dying again, but dealing with periods of incapacity. Does anyone know, in addition to get a guardianship or a temporary guardian, a first responder, what are some other important legal documents that might address not, again, death, but incapacity? And maybe you've had to utilize it for a parent who's older. Does anyone kind of know what those documents, powers of attorney, is that you kind of heard that word? I'm power of attorney, and people throw that around. So just an FYI on a couple things, because if I had to pick 2 documents that I wish every parent would have, no matter what they own, what their situation is number 1, have nominated guardians, and number 2, have the spouses have power of attorney for each other and hopefully a backup. Okay, so what is the power of attorney, and what would help? Why do I think it's so important? Well, again, most of my clients are younger, so it's not likely that tomorrow they're going to drop dead. It's more likely that they're going to be unavailable for a period of time. And those of you who are married, just because you are married doesn't mean you can do whatever you want for your spouse. Just can't. It's not automatic. We might think it is, but if technically we delve into the technicalities, we look at, you need to authorize your spouse in writing to do certain things for you. Something as simple as picking up a prescription from the pharmacy. That often requires a HIPAA authorization under the power of attorney for healthcare decisions, the Advanced Healthcare Directive. What? So doctors violate HIPAA all the time. I fought with 3 weeks for my client who mother, so it wasn't a spouse situation, but the mother was with Kaiser, who I have nothing against. They actually were following the rules. They would not release any information to the daughter who wanted to transfer mom from the hospital ICU to a respiratory therapy center. And they would not release information without an authorization in writing. Of course, they ask for it, and if you don't have it, well, mom doesn't have capacity to sign something like that. So they're asking for it in the worst possible time because you can't get, this person doesn't have the what we call legal capacity to sign something like that. But they're basically what I divided powers of attorney into: a powers of attorney for financial decisions and powers of attorney for medical decisions. And again, people call it different things, so it gets confusing. There's a durable power of attorney for finances, a POA, a statutory power of attorney. At the end of the day, whatever version of the document you're operating from, it should theoretically give another person permission to do things on your behalf related to financial matters. Pay your bills, file your tax return on time, speak to the IRS, deal with government benefits, retirement accounts, things like that, in the event you don't have capacity to do so. On the other end, related to healthcare decisions, it's usually called an Advanced Healthcare Directive, and it says, here's my agent to act on my behalf for medical decisions. And it may get into, in these specific instances, what decisions do I want them to make? As we're right in that age where we're dealing with our young kids, but also sometimes aging parents, this hits my clients all at once. So we'll be talking about their own estate plan, and they think, do my parents have these documents? What if they're starting to get sick and I can't talk to? I had a frantic call from a client today where we've set up her estate plan. Mom and dad both need care at home. And mom has dementia, so now she needs 24/7 care at home. Well, so they hired a caregiver this past year. Unbeknownst to them, there's a law that has changed. If you have 24/7 care, you need to pay overtime for this time even that they're sleeping there. So she calculated they would have to pay her $77,000 worth of overtime, and they would either have to pay that to her or figure out what the risk is if they want to let her go, because she's asking now for $25 an hour and they can't afford it. And so we're looking at all these things that are respected, but I asked, well, does your dad have his power of attorney? Are you his power of attorney? Can you hire a caregiver if he's not making the right decisions? I have no idea. So once, like I said, you can get these documents from your doctor. You can get these documents online. You can get something going, which says, again, this person has the authority to have authorized to get medical information we have, make medical decisions, and if you want, which I recommend you consider doing, what kind of decisions would you want them to make? And this is often referred to as a living will. You've heard of that phrase. Once again, has nothing to do with the will that says where does my stuff go and who's in charge if I die. I don't know why it's named a living will. It has to do with medical decisions that we make, often in the scenario of an irreversible coma or persistent vegetative state. Do I want to pull the plug? Do I want to cut it off? And those, you'll see cases like that in the news where it wasn't clear and the family was fighting over who did what. We all saw, a lot of us still remember Terry Schiavo case. The husband said, I don't think she would want to live in the state, but he pulled out the respirator, but she could still breathe without that, but it was artificial hydration nutrition at issue. And it wasn't addressed in the document she had, so there's a battle about that. Casey Kasem was recently in the news, if anyone saw that, the radio celebrity, where wife number, I don't know what, had a healthcare power of attorney for him, but it didn't address whether she could limit visitation. So she, under that authority, was keeping out kids from a prior marriage. And there was a huge, I know the attorney who actually represented one of the daughters, and it was really sad because that whole fighting at the end of the day resulted in him becoming very sick, right? Because he was neglected. They were so busy fighting it out in the battle in the courtroom. Wife absconded with him one night from the nursing home facility, went to like Canada or something, and he ended up getting a huge respiratory infection and then passing away based on because of that. So who you name in this position is also really important. It's usually a no-brainer if you have a spouse, or at least a good one, to say, okay, I need my spouse as my power of attorney to make these medical decisions for me. One other comment on that before I move on to some of the other more permanent situations of passing on assets. Not, like I said, these documents, something is better than nothing. So getting your healthcare directive done from your doctor would be great. You'll probably have a HIPAA authorization. Powers of attorney for finance is a little bit niftier. So you can download, there's something called a statutory power of attorney off the internet. You can download it, you can do LegalZoom. And like I said, I would encourage something, which is usually better than nothing, not always, but usually better than nothing. The problem is you'll sign this document, and again, once again, we have no prediction of when someone will actually need to use it. So two problems that come up, well, probably more than two, but two I can think of at this point. Number one, banks or financial institutions don't want to see a 15 or 20-year-old power of attorney. They are so on hyper alert for financial abuse, particularly elder financial abuse, that if they see something that looks like it's been done online or the LegalZoom or Susie Orman, there are going to be red flags going up, because it's very easy to get, especially an older person who's susceptible to undue influence, to sign something in front of a notary. You can do that. And so they're going to flag it, and you're going to have a problem with their legal department accepting this document. So one of the reasons, I think there are many, but you work with an attorney, is you can say, well, wait a second, we met with an attorney. So if they're capable or competent, they're going to confirm that this person has capacity to understand it. This is what their wish is. And I can certify, a few times what I've had to do is certify an affidavit basically saying I'm certifying this power of attorney under penalty of perjury, and backing up the document that, again, is just a piece of paper. I recently had a case where my client again brought in a mom who's super sweet, super nice, and there was always that rogue child, and everyone was on the same page. We wanted to name both of the daughters as co-agents. Well, about a month or two later, after we finalized the documents, son came in the picture again, took him to a whole nother attorney who redid the documents differently. So it's becoming an issue more and more as parents get older. But again, for your spouse, maybe something that's very important to have. Just again, the idea behind it is something's better than nothing, but not all powers of attorney are created equal. So often you'll get pushback from that financial institution will say, well, we want you to use our form. And you want to say, well, the reason I'm using this form is because my mom or dad or my spouse doesn't have capacity at this point to sign a new form. So you need to accept my form that I have and escalate it to someone else within the main branch that has more authority over those things. But again, something to think about, and they're simple documents. They're not expensive to do, or like I said, there's some resources to do it on your own. So at the point though we get to a more permanent situation where we're talking about not only the well-being of who would watch our kids if something happened to us, but also what would happen to all the financial stuff. So one of the things that I think is commonly confused a little bit is that a power of attorney expires when someone does. It's not valid beyond someone's passing. It's only for while that person is alive, and it goes away. You won't be able to use that in a bank when someone passes away. So does anyone know a document that would address, so power of attorney addresses while someone's alive, what addresses it? Does anyone have experience with a parent's estate? A trust or a will are the two main documents that you'll see commonly used in what we call an estate plan, which would include, again, the guardians that we've talked about, guardian nominations that we've talked about, powers of attorney, healthcare directive, and then often when we're talking about the assets, what you make them, we talk about two documents, trusts and wills. So I want to that's clearly my goal tonight. If everyone walks away with understanding the difference between a will and a trust, I'd be very happy. So both the documents tell us where we want our stuff to go and who would be in charge. Both accomplish that So it identifies clearly so family members aren't fighting over who's in charge. This is who I want, and this is how who the assets should be distributed to. Once again, there's always the default plan. So there's what we call a code section under our laws that say, if I don't have a will, I don't have a trust that says everything, where does my stuff go to? And depending on the characterization between community and separate property, between a married couple, it most often first defaults to the surviving spouse, and then children, and then it goes back up to parents, and then siblings and their kids. So there's this default line that your assets would flow through if you didn't put something in writing. So often you say, yeah, I would want it to go to my spouse. There is a difference, and I won't delve too deeply into it, but in California, what you acquire during marriage is community, something prior to marriage or during marriage from gift or inheritance is separate. So that actually doesn't all go to the spouse. Actually, if you have children, it goes half-half. Or if you have more than one child, it goes 2/3, 1/3. So it's interesting. I dealt with a case this year where the surviving spouse, all they had was she got prior to marriage, the house they lived in, and a rental place in Los Feliz. And they just kind of barely lived month to month based on her part-time job, and he was fairly disabled, so they lived off that rental income. And when he passed away, according to my client, it was 2 days before he was supposed to have his trust finalized, but he died of a massive heart attack. Nothing was in place. The kids that he never spoke to, ever, got 2/3 of the estate, and she's had to move out of her home. Both properties were sold, and she is actually pretty happy now that it's all settled, but she lives in a mobile home. That's pretty much based on all the bills being paid off. She got maybe almost $200,000, but that's it. What you can buy for that here. She lives in a mobile home, and she's very happy, but it was after a big stressful battle between the children. So, encouraging again to not rely on the default, putting in our wishes in writing. So again, what's the difference between the will and trust? In California, we have very specific, so this is state-based, it may be different in other states. We have a law that says if you own assets over $150,000, so our threshold is $150,000, that cannot pass, like you can't put a beneficiary on. So real estate is a good example. Then that amount triggers probate if you have a will or nothing at all. So a will for most of my clients just doesn't cut it because they own a home. Now it doesn't matter that they might have only $150,000 in equity in that home and have a mortgage for the rest. It's based on gross value, not net. Does that make sense? So what happens with the will when there's assets of that $150,000 or more? It gets lodged and starts a probate process that trickles into our wonderful court system. And all of the local, I used to love going to Santa Monica Courthouse. It's right beautifully, right at the beach. It was easy to get in and out. Parking actually wasn't that bad. All of the probate courts in all of the LA County region have shut down due to budget cuts, but one. So I don't even know where that one is, so we'll take a guess. Lovely downtown LA. Where to park, is just you have to finagle. You can take the metro now. It's actually not that bad. You can get out right before. But I just filed a case where the child is disabled, is an adult child who's disabled, and once she turns 18, the parents don't actually have legal rights to make decisions for her, but she can't make it on her own. And I filed this past month in July. I got a December 9th court date. So that's how slow we are moving. Which has made probate processes when we're distributing assets through a will or when someone hasn't done anything, probably 18 to 24 months. And if you can wait that out, at the end of the day, it goes to the beneficiaries, but not after a 4% fee on the gross value of the estate. And that's the kicker, because in this case, my client owned, if you remember, the husband who didn't do the trust, had a house and a home in a triplex in Los Feliz. So there was about $1.5 million worth of real estate, but nothing, maybe $5,000 in the bank. So again, no choice but to sell to pay off the loan and pay the fees, which were, again, about $30,000. So it adds up really quickly. A couple other things to think about when we have younger children is the default of not having something in place and it going through the probate process is they receive the distribution at age 18. So as long as they're 18, they're going to get the money, which for most of us makes us sort of cringe, right? What 18-year-old makes a good, conscious decision about money at age 18? Very few. Let alone do they even want the responsibility of dealing with money? We've been focusing on college and beyond. So for a lot of reasons, we do, as parents, do a little bit more detailed planning related to avoiding that court process. And instead of the answer that attorneys came up with about 40 years ago, so trust has been around about 40 years, was a document called a trust. And the major difference between a will and trust, besides bypassing a court process of probate, is that it exists now. So when someone says, I have a trust, they literally have a trust. A will, it just waits there and isn't going to do anything until someone's passed away. So the best way that I personally can explain a trust and understand it myself, because I'm a visual person, is that I think of a trust like a box. And what I do is when I sit down with families, I say, okay, we're going to design your box to say what to do. And then you got to you dump your assets inside. So if you've ever seen someone write a check with a trust name on it, that's because they've actually put that account inside of their trust. If you've looked, maybe if you've kind of noticed on a property tax bill it says your name, someone has a trust, it actually says their trust name on that property tax bill. And the biggest failure that I see on parts of attorneys, clients themselves, people in general, is they haven't actually put stuff inside of the box. So the way a trust works is when a couple approaches me to do it, we usually often do a joint trust. So they have to remember that they're actually wearing 3 roles as it relates to this trust. They're the people setting it up. So we call that, again, a couple different words that lawyers use, but often it's called a settlor or a trustor. So those are the person or persons who set up this trust. So they're wearing that hat. They are wearing a second hat, which is the manager or administrator of a trust. And that's technically called a trustee. Many people use that word trustee synonymous with executor. And it's not technically right. Executor is who's in charge of a will, and trustee is who's in charge of a trust. But it kind of means the same thing because they're doing the role of managing it all. They're in charge of this process. And then finally, every trust must have a beneficiary. So the beneficiary is also you. Just because you set up a trust, a few times I've had an older client get very confused by, I have to change the title on my house and my bank accounts. How do I get money then? It's all yours. It's not a separate entity for tax purposes. It doesn't change your ability to buy or sell. It just waits there in the background, ready to spring into action if we have certain triggering events. Number 1 triggering event, incapacity. It says if one couple is incapacitated, the other can step in seamlessly. They don't have to file anything. It's a private process. Through the document, it dictates what happens. And then as a couple, one of the hard things to think about is, well then, if we both can't do it, who's in charge next? And then, like I said, you're the beneficiary of it, so all of it's for your benefit. But it says, what happens when one of us does pass away? And the biggest thing that people puts them at ease when they do this process, and it's interesting how people react to the comment, but it actually is very protective for the children because it protects against casserole lady. What I call casserole lady, it's the lady who comes over to comfort someone after, and I'm sorry, I'm being very general, I'm generalizing, comforts husband after wife has passed away, moves into house, maybe they get married, maybe they don't, husband is grateful for her for taking care of her, and where does the house go when he passes away? All to her and her kids. So what the trust does, as you're designing your trust, you need to be aware, you can put protections in there that say, well, if I pass away, my portion of the whole goes to my spouse, but they can't change who it goes to. It at the end of the day has to be our joint children that we have together. And yes, people do get remarried.